Clement, the United States tells us that the decision of the Fourth Circuit, in your opinion, your position, would threaten universal internet access and emphasizes the problems that are encountered when that decision and your position are applied to a university account shared by thousands of students, maybe 50,000 students, and tens of thousands of staff members, or a regional ISP. And I really don't see how your position works in that context, but maybe you can explain how it could.
So I think the way that my position works most readily is that the safe harbor, I think, provides plenty of room for ISPs to handle things like multi-user accounts, fraternities, and the like differently, and you can have a different policy under those. The way this case was litigated below, my friends on the other side, I mean, you know, that chart on page 11, that was a demonstrative, that wasn't even introduced into evidence. They didn't make a big pitch that, like, our liability should be limited to just those customers. Part of the reason is because what the record does reflect in things that are in evidence, trial transcript pages 810 to 811 shows that 95% of the customers covered by the 57,000 sort of customers that are part of the universe that makes up the 10,000 infringement, 95% of those are residential customers. Only 5% are business customers. So I think there's a reason they didn't try to limit their liability to the 5%. And they took a position that was essentially, we stand or fall together.
Well, what is an ISP supposed to do with a university account that has, let's say, 70,000 users? What is the university supposed to do, in your view?
The university is supposed to, under those circumstances, the ISP is supposed to sort of have a conversation with the university. Now, the ISP's policy to the university says you can't use this service or allow your service to be used for copyright infringement. So that's
all right. The ISP tells the university, look, you know, a lot of your 50,000 students are infringing my copyright. Do something about it. Now, the university then has to try to determine which particular students are engaging in this activity. And let's assume it can even do that. And so then it knocks out 1,000 students. And then another 1,000 students are going to pop up doing the same thing. I just don't see how it's workable at all.
Well, look, I'm not sure that this record certainly doesn't support the notion that there are universities that have sort of undifferentiated service to 70,000 students or whatever the hypo is. I don't actually think that's how it works in practice.
How does it work in practice?
Well, the way it works in practice is with, let's say, let me take something that I know a little bit better, like a hotel. And so, like, a hotel has lots of guests. So the hotel is provided internet service, and the hotel then can do things starting with terms of use, but a lot of hotels actually don't provide their guests, at least in a normal way, don't provide their guests with services at a speed that are sufficient to do peer-to-peer downloading, precisely because they don't want to be in the position of having guests that are staying there largely so they can sort of upload and download copyrighted works. And if a particular hotel wants to be,
you know, think that's what a university should do? So students can't, students are restricted in what they can do?
I don't think it would be the end of the world if universities provided service at a speed that was sufficient for most other purposes, but didn't allow the students to take full advantage of BitTorrent. I could live in that world. But in all events, this isn't a case that's just about universities. We've never sued the universities. We've sued Cox, we've sued Grande, and I think it's worth, in thinking about the consequences of this case, I think it's worth taking a quick look at the brief in opposition in the Grande case, which is being held for this case, because that's a case where the ISP did exactly what my friend's position would incentivize, which is they did nothing with the notices.
It seems like